Limitation, as we generally know, is a mixed question of fact and law. However, there is no hard and fast rule that every question of limitation is to be treated as a mixed question of fact and law. In cases where the action is initiated after several years after the right to sue accrued, without any pleadings to explain the reasons for delay or as to when the fraud was discovered, the question of limitation is to be treated as a question of law. A recourse may be had to Order 6 Rules 4 and 10 CPC, which mandates that specific particulars would have to be given in the pleadings. Once such a plea is raised in the pleadings, then the burden lies on the person to prove that the delay was due to any plausible reason, and it is always well within the knowledge of the other party to contend and prove that the opposite party had prior knowledge about the disputed fact, and that his right to sue or defend had also accrued by that date. Even in the absence of specific pleadings regarding the limitation in the plaint or a plea of defense, there is a bounden duty on every civil court to ascertain as to whether the lease has been initiated within the time prescribed under law, even if the parties to the lease had not raised any objections. This right flows from the mandate of Section 3 of the Limitation Act, 1963. A useful reference may be had to the judgment of this court on this aspect in V. M. Salgaonkar and Bros v. Board of Trustees of Port of Mormugao, 2005, 4 SEC 613, wherein it was held as follows. The mandate of Section 3 of the Limitation Act is that it is the duty of the court to dismiss any suit instituted after the prescribed period of limitation irrespective of the fact that limitation has not been set up as a defense. If a suit is ex facie barred by the law of limitation, a court has no choice but to dismiss the same even if the defendant intentionally has not raised the plea of limitation. This court in Manindra Land and Building Corporation Limited versus Bhutnath Banerjee, AIR 1964 SC 1336, held in Para 9. Section 3 of the Limitation Act enjoins a court to dismiss any suit instituted, appeal preferred and application made after the period of limitation prescribed therefore by Schedule I, irrespective of the fact whether the opponent had set up the plea of limitation or not. It is the duty of the court not to proceed with the application if it is made beyond the period of limitation prescribed. The court had no choice, and if in construing the necessary provision of the Limitation Act or in determining which provision of the Limitation Act applies, the subordinate court comes to an erroneous decision, it is open to the court in revision to interfere with that conclusion, as that conclusion led the court to assume or not to assume the jurisdiction to proceed with the determination of that matter. In cases where the pleadings are silent, then it becomes the duty of the court to ascertain from the evidence and the overall facts of the case as pleaded by either party, and to render a finding on limitation where the question of limitation is to be treated as a question of law, since the court cannot entertain frivolous or stale claims. It is also apropos to reiterate the settled position of law that a question of law can be raised at any stage.